The prosecutor in the Danny Masterson case says he always thought he was going to get away with it. Could he still? Could the appeal actually get through? Christopher Melcher is about to blow your mind. Welcome to Popcorn Planet. I am Andy Signor. Honestly, I brought in Chris. I always love having Christopher here to talk about things. And we were going to talk about the case, but in our pre-interview, I was sort of blown away because, Christopher, you brought up a very interesting thing. You think there is a very big likelihood that Danny Masterson could, in fact, win his appeal. Is that correct?
Yeah, and it has nothing to do with guilt or innocence. And that's where, we definitely want to make that distinction, because Danny's argument on appeal, and the one that may ultimately win, has nothing to do with whether he did these crimes or not. It has to do with whether the prosecutor waited too long to file charges. And so legally, we have a statute of limitations. There's a deadline that applies for most crimes for which a person has to be charged. And that is hard rule, that if they're 1 day late, then charges cannot be filed even if the person is factually guilty of the offense. They can't be charged if they waited too long. And that is one of Danny's best arguments.
So let's rewind a bit, because that blows my mind to think. But this whole case has really blown up in a way. And honestly, let's keep it real. It's blown up because of the Ashton Kutcher letters. It seems to be what finally got people interested in this case, which is sad in itself, but it's the reality. We've been covering this case for a while, and no one was really interested or watching until these letters came about. But the reality is, let's talk about the case in itself, because you followed it very closely. I know you did, and sort of it's hard to follow these cases if no one's really paying attention. But you filed this case. I mean, you do believe Danny is guilty based on everything you've seen regarding the evidence in the trial, because a lot of people are out there trying to paint this picture that there's no evidence. They're using this excuse that it was too long, which is one we're going to talk about. But before we get there, do you believe there was enough evidence and credible testimony here to warrant, regardless of the time and the problem here, that Danny was in fact guilty?
Well, hey, none of us are decision makers here. We didn't sit through the trial, and we weren't charged as jurors, and we didn't have to make that really, really heavy decision. But there were jurors who did that. And, in California, it's unanimous. 12 jurors came to a conviction of, beyond reasonable doubt after hearing all the arguments for or against, listening to all that evidence and testimony at that trial, and said that he was guilty as to the first two victims. The third one, they could not agree on, 8-4. So I think eight voted for conviction and 4 were not guilty. So there was no conviction as to that one. But hey, I don't, substitute my judgment on behalf of, for these jurors. If you ever served on a jury before, it is a huge, huge sacrifice of time. They might get their parking paid for and hopefully maybe get their wages paid for by an employer or something like that. But they're giving up every day for many, many weeks of their lives listening to this. They take a solemn oath to listen and be unbiased. And so my thing is, I go with what the jury has to say. Now, I've looked at this evidence, and again, I was carefully studying this case on the run-up to it. So I looked at the prior statements that these folks had made, and they give graphic accounts, and they're similar graphic accounts. Okay, so there's similarities. And I know people are saying, oh, well, it's coordinated. No, it's not. There is no evidence, not a scrap of evidence, that any of these victims knew each other before they came forth. Okay? You will not find that. They do not know each other. So they each had very similar stories to tell that happened individually. So it's not some group thing that happened.
And not to interrupt, but they reported, right? That's something that a lot of people also get incorrectly, that they never told anybody, but they did report this to the Scientology officers, correct?
Yeah, so one of them went through the Scientology kind of chain of command, and that was expected of a Scientologist to, report that internally and deal with it internally without going to law enforcement. So she went through that process. Another one told, I believe it was her mother. And so, as to the 2 that were convicted, they did report it in their own way near in time to the event. And Danny paid $400,000 to one of them not so long after. And that was noted in sentencing by the judge that, sure, there's a lot of reasons why you would pay to settle a case, even though you did absolutely nothing wrong. That is the right decision to make in most cases. But sometimes you do that, it's $50,000 or $100,000. Here it was $400,000. So it's a lot of money.
That's a lot of money, no? That's a lot of money. And that was for the
and
civil,
we're talking,
right? That still allowed her to... Because that means, sorry, but it was just so I'm clear, like one could argue to the victim too, well, why would you take the money? But that was for the civil part, whereas she still could then file the criminal charge?
That's right. You can't release criminal liability. So even though you settle the civil part and in exchange for the $400,000, she can't go after him for more money. But in no way can you release yourself from criminal liability because victims don't file charges. You know, you hear that a lot. Oh, I'm filing charges. No, you're not. Only the prosecutor, only the state of California or federal has the authority to bring criminal charges. So even if the victim doesn't want to cooperate, they still have the right to bring those criminal charges. So there was a big settlement, and, and again, maybe he had reasons to keep his reputation quiet, but that's a lot of money for Danny, and that's 20 years ago. So that's a lot of money, obviously now if you kind of adjusted it. So look, I mean, to me, when I was following the case, it seemed credible to me. And then obviously it was to the jurors. So I think we have to respect I have to respect what the jurors had to say. Now, the thing that always bothered me, though, about this case is the delay. And we've seen so many of these cases where allegations are made, criminal, civil, or just in the press, for things that have happened 20 years ago. And I understand there's reasons why people won't, bring things forth earlier in the Me Too and all that kind of stuff. But it always bothers me. I think it's terribly unfair to the accused because if you're accused of doing something yesterday or a year ago even, you have the ability to gather evidence. Your recollection is there. Your witnesses are still alive and available. They remember events, emails, photos, other stuff is there. You could gather it and put on a defense. If you're accused now of having done something 20 years ago, good luck to you. Finding victims witnesses, are they even alive anymore? Have people thrown out those records? So it puts the accused at a terrible disadvantage. So that was the part that always bothered me, even though I felt like, hey, it seemed like the victims were credible in what they were saying. But I don't like the delay. And I understand the reason for the delay. And that was a big part of the case was that, at least with the Scientology involvement, the allegations at Scientology actively dissuaded them from bringing the allegations, to the forefront earlier on. So I understand all that's part of the case, but again, still bothered me. When we start pivoting here now into the story away from what we believe, if it's relevant, whether somebody's guilty or not, to the deadline, the statute of limitations argument. Again, that has nothing to do with guilt or innocence. It has to do with, did they file this case timely?
And so I guess that's the question. Did they? It sounds like that's what the fight's going to be. And do we know that for sure? Is that something that can already sort of be shown?
So here's the argument. Danny came in, he filed this thing called a demur. And so it's an objection to the legal sufficiency of the criminal complaint early on. And he said, look, the statute of limitations, the deadline to bring charges like this is either 6 or 10 years. And this was brought 20 years after. So he just said, it's out, it's done. Now, the prosecutor came back and said, look, we get that. That's right. If it was just a complaint against a single victim, we would be too late. They acknowledged that. But they said, we're bringing this case not against a single victim. We're saying that there's 3 victims here. And in California, we have a one-strike law. And the one-strike law says that if somebody does, and again, we're careful with our language, but if somebody does an offense like this, a very bad thing,
yes,
to multiple victims, so the R thing with multiple victims, then they can be sentenced 15 years to life, because you saw all that confusion about what does this to life mean. This is where it comes from. If you have multiple victims, so it has to be 2 or more people, the same type of offense, the mandatory sentence is 15 years to life. And so the prosecutor is saying, hey, the California Penal Code says that if a criminal offense provides for what we call an indeterminate sentence, meaning could be a life sentence, there's no deadline to bring the charges. So, for example, murder is and hopefully you can say that word, is an indeterminate sentence. So if somebody's charged with that horrible crime, they can be charged 80 years later if they're still alive. There's no deadline for it because the crime carries a potential life sentence, and therefore there's no deadline to bring that charge. So that's the argument the prosecutor said here, is that because this carries a potential life sentence, it doesn't have any deadline associated with it.
Well, it
Danny's
also
come back.
it allowed that, right? Because the case wouldn't have happened if that was determined to be true. No, I mean, false.
That's right. So the prosecutor acknowledged that had they not been able to bring these three, but they only needed two. So they acknowledge, the prosecutor acknowledges if they didn't have two or more victims of the same type of offense, that they would be too late. The only way that they could charge him 20 years after the fact is if they had the two or more victim allegation. Now, Danny's coming back and saying, okay, fine, you have two or more victims, but those did not happen at the same time or even in coordination. It wasn't like, we see some crime sprees, stuff where somebody goes to one house and then, 5 minutes later, they're at house number 2 doing the same thing. He says this wasn't, happening at the same time or even in series. These are separate events, as I've noted before, that people didn't even know each other. So, should he be charged with the multiple victim allegation, even if that's proper, where he's kind of a serial R guy, which is what they're alleging. So it could be totally different random victims. Okay, fine, let's accept that. But his other argument is like, hey, that potential sentencing enhancement of 15 years to life doesn't describe the crime. It describes the sentence that's available. And this is really technical stuff that Court of Appeal justices love getting into. So the 15-year to life is more of a sentencing enhancement or sentencing scheme is what Danny's claiming. And therefore, it doesn't describe the crime itself. It describes the sentence that's available, and therefore they had to bring it within the 6 or 10-year statute for the crime itself, the R. So again,
and
highly
that's each one
technical
separately.
legal stuff. Yeah.
And that would be like
so
each
what
one separately, not combined, is what they're trying to argue there.
Yeah, I mean, they could still try it together like they did. They could sentence him potentially to life, but they needed to bring the charges within either the 6 or 10-year statute as to each of them. And they're way, way beyond that. They acknowledge they're way beyond that. So that's the key issue on the appeal. And again, this is really, really technical stuff. And it has nothing to do with whether he did the crime or not. It has to do with what the law allowed for the timing of bringing that offense. And again, and I do a lot of appellate work. This is the stuff that appellate justices love getting into because we as, a justice system have to make sure that we're following the law. And if the law says that the crime has to be charged within a certain time, we have to follow that. And if it was done a day later, we have to dismiss. So this is his main argument. His secondary argument is, hey, even if technically he could be charged 20 years after the fact, that there was prosecutorial delay that violated his due process rights, that issue that I was alluding to earlier, that one of them had gone to LAPD earlier on. So, hey, the state is aware of the allegation as to at least one of them. And the fact that they waited so long to bring charges when they could have done it earlier, there was no reason why they could not have filed. The moment she walked into LAPD's office, they could have filed right then. But they waited many, many years after the fact. And the fact that because they waited, he did not have the ability to gather evidence and defend himself, bringing in witnesses who had fresh recollection as of that time. That's his argument. Prosecutor says, hey, that would be a good argument, but you have no proof that any of this evidence that was available back then is no longer available now. So again, this is what an appeal
Chicken
is
before
made
the
out
egg.
of.
I mean,
this
that's
is
a
my
weird
sense.
debate.
Yeah, and it's like, that's why, okay, I think, you look at Danny Masterson in court, and it was noted by the court. You're kind of sitting there smugly. It's not her word, my word. but kind of smugly sitting there, unemotional. Danny, you have not acknowledged any responsibility for this at all. You've shown no remorse, so I'm going to throw the book at you. The reason why I think he's doing that is he's banking on this appeal. And so he had to make a decision. Does he go into court on the sentencing hearing and say, yeah, you're right, did all this stuff, but I'm a good guy. Here's my excuse. Please don't throw the book at me. Give me 15 years, which the court could have done, instead of consecutive sentencing. So the court said, I have to do 15 years to life. That's the minimum mandatory. But they could have had those run concurrently.
Right.
So 15 years for one, 15 years for two, run at the same time. So that's a 15-year sentence. The court had discretion, though, to do it consecutively. So as to victim one, you're going to do 15 years. And the moment you're done with that, then you start the sentence for victim two, another 15 years. That's what the court did. And the reason why the court probably did that is because he showed no remorse. He took no responsibility. But had he done that, he would not have had an appeal because he would have been admitting guilt. Mm-hmm. So this story is not over. It'll take at least 18 months to 2 years for the appeal to be done. He might even go up higher with it, and to higher courts. But we're gonna at least 18 months to 2 years from now till we have the decision. That's what he's banking on, and that's why he just sat there unemotionally.
Yikes. Well, it's interesting because there's the mind. I had a lot of questions, but that was the one I realized, no, let's talk about this because that's a mind blow right there to think about it, because I think people are just assuming this was a done deal. But now you realize there's clearly more behind the scenes of what he's thinking, that blowing the kiss, etc., things that he's done. But I'm glad we bookended it with the fact that, there's a lot of damning still evidence here that people say there isn't, that really doesn't paint him well. And even this, he's relying on basically a technicality to get away with this. Not like there's damning evidence, judge, that proves I didn't do it. It's more like you guys didn't file it in time, so I'm going to get off, which doesn't help me think he's innocent. It's just a way for him to get away with it, is what it does seem like. And it goes against what the prosecutor's saying. He always knew he was going to get away with it. There's almost this idea in his head, no matter what, don't worry, in the appeal we got it because they're too late. I guess my final question is why isn't this type of thing sorted out before the case even begins? This went to trial twice. If this was such an issue, you'd think this would be beaten out beforehand by Danny's team or by somebody's team to ensure that this isn't some weird technicality that he can win on. Is there got an answer for that?
Well, sure. They filed this thing called a demurrer. You can find it, online. If you search for Danny Masterson demurrer, it's DUMURRER. You'll see the demurrer that he filed. You'll see the opposition by the prosecutor. Judge Olmedo, who's an amazing judge in LA, and she is super smart, knows this stuff better than I do for sure. She ruled on that. And so she went through all those arguments very carefully and said, from her legal perspective, she disagreed with all those arguments and said, this is an indeterminate life sentence and therefore there's no deadline to bring it. That's the way she viewed it. However, on appeal, the Court of Appeal justices do not defer to the Superior Court judge's view of the law. Okay, so that's what we call a de novo legal issue, that there's no deference to what the lower court believed the law was. The Court of Appeal will look at it anew and saying like, hey, we can read these statutes ourselves. We don't need help. So we're going to read these statutes on our own and come to our own conclusion. Now, they may come to the same as Judge Olmedo did and the prosecutor did and said there's no deadline, or they could say, hey, we agree with what Danny had to say and that there was a deadline and they blew it. So all that's been argued and preserved, and it was overruled. So that's why they had to have the trial on the merits of the case. Danny lost. He was found guilty as to two of the victims, and therefore he goes now and he's been sentenced. Once that's verdict is entered as a judgment, he will appeal, and again, it's a long process.
Fascinating. There you go. Well, you can follow Christopher Melcher for more updates on this and so much more. Make sure to give him a follow if you like what he's bringing. And you may not like what he's saying, but respect that he's bringing it. Don't be mad at the messengers here. If you think Danny's guilty and you're mad to hear this, it's good for us to be prepared. And this is clearly something that his team is preparing for. Always a pleasure, Christopher. Thank you. Make sure you hit that subscribe button if you haven't already. Hit the bell for all alerts. Smash the like button and leave a comment down below. What do you think? Are you surprised? Do you think this is likely? Do you think that's what Danny was banking on? I want to hear all your thoughts down below. Also, click on these videos and stay tuned for more here on Popcorn Planet.